but I do want to stay on this case. Joining us live tonight is attorney Mike Levine. He represents the school district in this case. Sir, we appreciate your time tonight. This was an 8-1 decision. The court siding with this student, the former cheerleader, and her First Amendment right to free speech. First of all, your reaction to the court's ruling today.
Sure. We were actually very pleased with the court's ruling because we presented only one issue to the court. And that one issue was, do school districts have the right to control off-campus speech? The Third Circuit had held that school districts do not have the right to control off-campus speech at any time. It was a bright line that they were trying to draw. And we appealed that ruling and that part of the ruling, and we won that part of the ruling. The United States Supreme Court clearly held that school districts do have the right to control, under First Amendment principles, the speech of students off campus, just like they have the right to control it on campus. And the same rules apply. And the court enumerated a number of times and issues where school districts can take action. They went further than simply decided the legal issue we raised. After deciding the legal issue we raised, they applied the legal principles to the particular facts, and they concluded that the school district should not have disciplined the student under the facts in this case.
I'd like to share with you, Justice Samuel Alito wrote, and I want to quote him here, "If today's decision teaches any lesson, it must be that the regulation of many types of off-premises student speech raises serious First Amendment concerns, and school officials should proceed cautiously before venturing into this territory." That sounds like a warning. How do you take that to mean?
Well, there's a couple of reactions I have. First of all, Justice Alito's decision was not part of the majority decision. That was a concurring decision that only one other justice joined in on. 6 justices did not agree with that concept. That said, I agree with the general proposition that both on campus and off campus, speech has to be critically reviewed by school districts to make sure that the speech is not protected under First Amendment jurisprudence.
Historically, I mean, we're talking 50 years here, the court has not ruled in favor of students in similar cases such as this. What role does social media play in this case and today's ruling, and how did it differ?
Well, the role is all of the critical issues that social media presents that were not even thought about back in 1969 when the court decided the Tinker decision. And school districts are wrestling on a daily basis with bullying, with harassment, with all kinds of inappropriate conduct. I have another case right now pending in court where a student made threatening behavior and it seriously disrupted a suburban Philadelphia school district. And of course, the students' attorneys were arguing, based on the lower court decisions in this case, that because it was an off-campus conduct, off-campus threat, we couldn't do anything. This case clearly says that the school district was right in that suburban Philadelphia case, and I expect that we will win that and hold the student accountable in that case.
Just to be clear, though, for folks at home, I mean, the court today, by a majority, ruled in favor of the student and her free speech, just to alleviate any ambiguity in the case. So legally speaking, what would be your advice if you are giving legal advice to any school district across the country when they start to dip their toes in this territory when a student posts something online off campus?
Well, the court also made clear that any decision will be looked at and evaluated in light of the context, and all of the facts will be taken into account. So when school districts want to take action to protect other students, for example, or to hold the student accountable for his or her action, they have to look at all of the facts and apply all of the nuances of the case to the particular jurisprudence that we're looking at. What is a threat? What is harassment? Does it meet the standards? And the court decided today, based upon the arguments that we made, that the same analysis that applies in school applies out of school.
And taking into account the impact of social media in this day and age, Mike Levine, attorney representing the school district in this now historic case, thank you for your time.
Thank you. It's been a pleasure.